breaking news coming in from the national capital as far as the liquor gate is concerned. There's an anxious wait for the Delhi Chief Minister that begins now as the Supreme Court reserves its order on Kejriwal's plea. Well, that's big breaking news that we're getting you at this point in time, where Kejriwal had sought bail in the CBI case. The Delhi Chief Minister also opposed arrest by the CBI. Well, that is the big breaking news that we're getting. My colleague Harish is joining me on the phone line. Well, Harish, take us through what panned out in today's hearing as Supreme Court reserves order on Kejriwal's bail in the CBI case.
A very long marathon hearing. The Supreme Court has reserved its verdict in the petition filed by Arvind Kejriwal, the Delhi Chief Minister, seeking bail, as you rightly said, in the Delhi liquor scheme, and also the second petition wherein he has challenged this arrest by CBI. Why this petition is important for Kejriwal is that Kejriwal has been granted interim bail by the Supreme Court in the ED case, and if he gets bail in the CBI case, in which he is in judicial custody at present, he will come out of jail. He will be a free man as for the time being. In fact, the appearing for Arvind Kejriwal, Abhishek Manvi, the senior advocate, argued that Kejriwal's arrest by CBI was an afterthought insurance arrest. After Kejriwal secured 3 release orders in the ED case, they anticipated that sooner or later he would walk out. To ensure he stays behind bars, CBI arrested Kejriwal to ensure he stays behind bars, and arrest is solely relying on subsequent, contradictory and highly belated statements in the ED case of co-accused who have now turned like Raghav Magunda Reddy, Srinivasula Reddy, and these statements of all these approvals are based on hearsay, and they have not even Kejriwal once. Even the Kejriwal legal team also said that it's an attempt to take away liberty in a high-handed manner, and CBI and on its part argued that during ED custody, Kejriwal had been examined, interrogated. However, he did not cooperate with the investigation and deliberately gave evasive replies to the evidence on record. And also, towards the end, the ASG Raju, who appeared for CBI, said there are several witnesses who were not ready to depose till Kejriwal was arrested. All these witnesses will turn hostile now under pressure if he gets some relief. And after stressing on chances of influencing of witnesses, concluded his arguments. And also, the ASG Raju said Kejriwal shouldn't have been allowed to move High Court as court of first instances. Ideally, he should have been he should be asked to go to the trial court to seeking bail and also quashing his arrest, and he should not be allowed to jump hierarchy. There is a different judicial hierarchy which has to be followed. This was one of the other argument by Additional Solicitor General S.V. Raju, who paid for CBI raising the preliminary objection. He said first court to raise the plea is trial court, High Court or Supreme Court can be approached rarely. And the other ground raised by Abhishek Singhvi, the biggest ground raised by Abhishek Singhvi is that already there are 3 court orders in favor of Arvind Kejriwal in the ED case, and the very tough PMLA case were getting difficult. 1, the interim bail given by Supreme Court for campaigning. Number 2, the regular bail given in the ED case by lower court. And number 3, the interim bail given by the Supreme Court in the ED case.
Right.
So the biggest argument put forward by Abhishek Singhvi is that already he has 3 court orders ordering his release. So that should be considered while deciding his application as far as seeking bail in the CBI case is concerned. Back to you.